Hello, good evening, welcome to UPfront. My name is Raymond Alqua. Tonight we are asking, is this a legitimate transaction or yet another example of looting of state lands? We put a spotlight on the Achimota Forest declassification that has generated massive controversy as the Occupy Ghana breaks long-held silence on the matter. Of course, there is enough pressure that's been mounted on government to rescind its executive instrument, which is declassified Achimota Forest as a forest reserve and awarded over 360 acres to the pre-acquisition owners, that Owu family. Now, government has also tonight been fighting back. There's been insisting that it is just implementing a deal agreed by the NDC in 2013. In this interview with my colleague Evans Mercer, Minister Samuel Lebu Jinapo shifted the blame of increasing the land to be released to the family from 90 to 360 acres to the previous government. Listen to him.
And secondly, I see in your statement that under John Mahama, there was 227 hectares that were also given out for some private development into an ecotourism.
In fact, that is not just 200 and something hectares. That is the Achimota Forest.
Okay.
The Achimota Forest was granted to Akins Capital by the Mahama administration.
For what exactly?
To develop it into an ecotourism park. An ecotourism park is essentially like a theme park, to more like level the forest and build a theme park there. And leases were granted to Akins Capital. We have had to come into office to decouple the two issues and say no, the ecotourism park is not something that we are persuaded by. So that we put a hold on it so that Achimota Forest will be salvaged, will be saved. The Mahama administration. And look, I don't like to get into the realm where we politicize these things. We don't have to, where everything is politicized, and which is what our friends are trying to do. It's not everything that should become a political game where we kick it here and there. But that's a fact. They granted the entire Achimota Forest. They did. President Mahama did two things. He said the portions which the Owu family are entitled to, give it to them. Then the Achimota Forest, give it to Akins Capital and let them develop an ecotourism. That's a matter of record.
So you're actually listening to the minister clearly stating that it was not this government that decided that more than the 90 agreed by the Kufuor government should be given to the family. The 360 acres we are talking about was decided by a committee under the former government in 2013. We'll be joined pretty soon by the former Minister for Lands and Natural Resources at the time, Inusa Fuseni. We'll also be joined by a man who's been legal advisor for that particular ministry for a very long time and has worked on some of these agreements right from the years you should know about. That is lawyer Kwame Jan. Pretty soon on the conversation. One of the major things that's also happening tonight is that Occupy Ghana has been issued a statement on this particular development. What Occupy Ghana has been saying is that we should respect the agreement with the group. That is the group we are talking about. If I'll read to you sections of the statement they are put out there. It says Occupy Ghana disagrees with any further release of Achimota lands and says they have followed the public discussions on the issue of reclassifying some parts of the land acquired in the 1920s and classified as the Achimota Forest Reserve. It proceeds to say that the Achimota Forest Reserve, and we have formed the view that apart from the portions leased back to the original, and that's important, you know this, original owners in 2013, government should hold the rest of the land, maintain some of it as a green belt, and use the rest of the broader national interest. The history of government's holding of compulsorily acquired lands is nothing to write home about. The overall management of these lands has been haphazard and messy. Record keeping, it continues, has been largely and sometimes deliberately derelict and shambolic. And the 2015 report of the sole commissioner on judgment debt shows how government has been defrauded into paying compensation on such lands when none was due. There is also evidence of how some of these lands, under the guise of being returned to the original owners, have ended up in the hands of government and party officials. These factors combine to make Ghanaians extremely suspicious of any land transactions involving government, and for good cause and reasons. We note that Article 20 of the Constitution, the statement continues, provides that the original owners of compulsorily acquired lands should be given the first option to acquire them. When these lands are no longer required for the original purpose, we are also aware that the Supreme Court has held that the provision does not apply to lands compulsorily acquired before the current constitution came into force. They proceed to elaborate on the Article 20 and its effect, and says Article 20 does not apply to the Achimota lands, and government is under no obligation to either return this or any such land to any or original owners to exercise first option to buy. However, this is the point they make. Granted that government has already agreed to release some of the land to the original owners by way of leases dated September 2013, and is therefore contractually bound, and that should be all. We strongly believe that government should hold the rest of the land for, specifically it says, other relevant national purposes. We do not find it to be in the national interest to return any further lands to the original owners. Government cannot give the impression that it has no interest in holding and managing land in the wider national interest. That is very wrong signal. That is what's saying about the Occupy Ghana situation, and gross dereliction of its duty to the generality of the Ghanaians on whose behalf it holds such lands. Now, there is more to this statement. It also says that we therefore urge government to rethink this matter and freeze the size of the lands to be returned at the size stated in the 99-year lease agreement executed in 2013 with the original owners and nothing more. And this is important because whilst the understanding of the minority is that they are unaware how government moved from 90 acres to be given to the old family to 360 acres, this statement is in tandem with what I just played you from the current Minister of Lands and Natural Resources, that a 2013 agreement was done to move it to 360 acres. But the Occupy Ghana statement actually adds a few more sentences to this. It says government should then come back to the people of Ghana on whose behalf it holds the land with a clear development plan that considers and includes the original forestry purpose and other modern uses to which the land may be put. It also says here, we also use this opportunity to urge government to freeze all planned return of compulsorily acquired lands, and also says government cannot and should not be returning any compulsorily acquired lands or state lands. And there appears to be a serious disconnect in government's policy that returns lands for nothing at a time when the health minister has announced that the Agenda 111 is stalled because of land litigation problems. The final sentence here says, further, we urge government, if it has not already done so, to conduct and publish an audit of all the lands it holds and come up with a clear national strategy on the use to which those lands are better or will be put to serve our national development goals. So that is what Occupy Ghana is already saying in this particular statement. As I did tell you, we should be joined by the former minister under whose watch many of these incidents and occurrences did happen, and the 2010 incident happened. But before we get to the former minister, let me speak to a man that you surely would know in the area of land law in Ghana. He is an expert because he's been in the Ministry of Lands and Natural Resources as an advisor, a legal advisor, way back in the 2000s, and he still does a lot of work in the area of natural law. Lawyer Kwame Jan, you're welcome to our front. If you can hear me, say you're welcome to our front. I hope you are doing well.
I'm doing well.
Now, I was just telling the people that if there is anybody with a proper appreciation, understanding of land law, I doubt if anybody can skip you in this particular case. But this issue is particularly interesting because you have worked on it. Briefly, where have we come from with this particular deal? Right from when the land was acquired for the forest and the other things and the schools that we found it to be till today. What has been the trajectory of events that's led us to this day?
I extend a very good evening to you and your cherished listeners. I really didn't want to talk about this matter, you know, because these days, when you express your views on matters, even if they are your technical views, foot soldiers and other people will just pounce on you and insult you. But occasionally, we have to do these things for God and country.
Very well.
Raymond, you may remember, if you may not remember, let me tell you that from about 2003 to 2011, thereabouts, I was the legal consultant at the Ministry of Lands and Natural Resources.
Yeah. And
in 2006, a petition was sent to the President of the Republic at that time, President J. Kufuor, by the Owu family, praying for the release of a portion of the Achimota forest to the family. We were referred to work on the petition, myself and a gentleman called Danajiman. May he so rest in peace. He was Deputy Chief of Staff under Mr. Kojo Impiani. So we did some work, and then the matter just stagnated. So somewhere in 2007, another petition was brought to the presidency, which was again referred to Danajima and myself. So we worked on this one too. We had a series of consultations, and at that time, somewhere in 2008, the consensus was that there should be a redevelopment of a part of the Achimota Forest Reserve into a new Accra CBD, Central Business District, to ease the congestion in the existing CBD. So after a series of consultations and meetings with the Owus and other stakeholders, I remember very well, towards November of 2008, an MOU was signed between the Ministry of Lands and Natural Resources. The minister was then Madam Obindapa. An MOU was signed between the Owu family and the ministry for the release to the Owus, of 193 acres of the Achimota Reserve, and the state was to apply the rest of the land for the development of a complementary CBD for Accra. Now, this was not materialized, and the MPP lost the election in 2008. So somewhere 2011, I think I got tired at the Ministry of Lands, so I went back to Lagos. Now, so let me end here for now and take you back a bit.
Okay.
This Achimota School land we are talking about, there is a land which was acquired in 1921 for educational purposes. That is it's about 4 square miles or something. And for that portion, full compensation was paid at that time to the Owu family. I'm not in Accra, I'm somewhere in Milan. I have copies of the receipts in my documents at home, but where I am, I can't find
£4,000.
I can't find any document where I am.
Okay.
But I know that full compensation was paid.
Okay.
This is 1921.
All right.
Then, subsequent to that acquisition, in 1927, an additional land was acquired from the Owu family as an extension to the Achimota school land. Now, this was 495 acres. I think it's, 495 acres, or about 1,223. No, it's 495 hectares, which is about 1,200 and something acres. And a hectare is 2.5 acres. So 495 thereabouts to about 1,220 something. This land was in 1930. The extension land was in 1930 converted into an Achimota fuelwood plantation reserve by the publication of an executive instrument by the colonial governor. So at this time, you are talking about 1930. There was no precedent. And the law that governed reserve creations, which is still the law, is the Forest Act. It used to be called the Forest Ordinance of 1927, Cap 157. The Forest Ordinance of 1927, Cap 157. It is now called the Forest Act of 1927, still Cap 157.
Okay.
Now, Section 2 of Cap 157 says that for any land to be constituted into a reserve, it must be published in a gazette by the governor. Now we don't have a governor, we have the president. So the Statute Law Revision Commissioner made some changes in the existing law and replaced the governor with the president. So Section 2 of Cap 157, which is the Forest Act of 1927, provides that where land has to be constituted into a reserve, it should be by way of an executive instrument published by the president or on the authority of the president.
Very well.
The same Cap 127 in Section 19 says that where any piece of land has to no longer be a reserve, it has to be published in a gazette by the same means. So you gazette land to become a reserve in Section 2, and you de-gazette land to cease to become a reserve in Section 19. Raymond, am I making sense at all?
Exactly. I mean, and it fits into what has happened now that people are questioning. Why did we gazette and de-gazette the lands here? So that's the point I get from what you're saying.
So there is a judgment of the Court of Appeal of the Republic of Ghana in the case of the Forestry Commission versus Metro Mass. This is a decision of the Court of Appeal sitting in Tamale. I can't find the judgment where I am sitting, but there is a Court of Appeal judgment. Justice Dennis Agay and now Supreme Court Judge Lovelace Johnson and a third judge sitting in the Court of Appeal in Tamale on an appeal from the High Court in Tamale. The Court of Appeal said forest land would be gazetted by the authority of the president by way of an executive instrument, and would be de-gazetted by the same authority by way of an executive instrument, and said no other authority in this country can do that.
I see.
So this thing called de-gazetting, I am surprised that it has become a problem. Legally, it is simply the mode by which you constitute in Section 2 and the mode by which you deconstitute in Section 19. It's not coming from the moon. It's just the law, which has been affirmed by the Court of Appeal.
It's interesting because the competing view is that it was not warranted at all, that merely by gazetting it, removed the ability for us to see the entire environment as an eco-friendly zone for any form of development at all to come up there. That's the computing view. What do you say to that?
You see, let's look at the competing view and the foundation of the competing view.
Okay.
I have stated clearly and unambiguously what the law says.
Certainly.
So when you get to these kinds of arguments, when law is cited, you bring a superior appreciation of the law, and we sort it out between ourselves as professionals and students of the law. So it is not about having a competing view. It is about grounding your competing view in superior legal argument. That's all.
Now,
so is the competing view saying that de-gazetting is not a legal requirement under our law after Section 19 and a pronunciation, unanimous decision of our Court of Appeal, which has not been the subject of a further appeal to the Supreme Court? I mean,
there is also something that's bothering the minds of many, and this is to do with the change from 92 acres to 360 acres. Now, can the de-gazetting result in the increasing of the acreage that's given to a family under this arrangement? The question being asked essentially is that what can governments do, and at what point in time can a recommendation by a committee be the foundation for this new act of de-gazetting?
Ray, in 2008, the MOU that was signed between the Ministry of Lands then, which is still the Ministry of Lands now, because the government, yes, the people who manage the affairs of state will go, but state institutions stay. The memorandum at that time, yes, you would say that it's an MOU and may not have all the totality of binding force.
Certainly.
But the agreement at that time was 193 acres in 2008.
Not 92.
193 acres. This agreement is in the public domain. It's available I even have copies. It's available in the records of the Ministry of Lands and Natural Resources. It was signed between the minister and witnessed and the OUs and their people. So it was signed. 193 acres. But at that time, the plan was that the totality of the forest would be de-gazetted, and all the rest of Achimota Forest would cease to be a forest reserve. This was the plan. If you read the MOU, that's what was clearly stated, that the remaining portion of the land would become a complementary CBD for Accra.
Oh, I see.
So there was no idea of retaining any reserve at all under the program of 2008. So subsequent to that, and with the change of government, the idea changed from a CBD concept to an ecotourism park concept, so that there will be releases of peripheral portions of the land which the Forestry Commission would recommend as not being suitable for the ecotourism park to be released. And the rest would be turned into an ecotourism park, which will have three components. There would be a theme park component, which would ensure that the religious activities and other activities that currently go on in the reserve would maintain. And there would be an ecologist component, which would set up round houses tuned to our cultural setting within certain areas of the reserve. And there was a plan to include a commercial enclave as part of the ecotourism project. So these things are on the table. So for all that I know, the portion of the land which is reserved for ecotourism would still be a reserve, untouched by the Gazette notice.
This current one?
Yes, this current one has no effect on the land which has been allocated for the ecotourism park.
But
so it is not the case that the instrument would affect the entirety of the Achimota forest land. No.
The concern here is how did the allocation move from, you say it's over 190 something, but to the 360?
And what I believe is in the previous government, there were still negotiations with the O's and their stakeholders. And I think that this figure is the last they have agreed based on maybe the recommendation of the Forestry Commission, because from the beginning, at the time that we were planning this, the Forestry Commission's argument, I mean, when during the former President Kufuor's time, when Danajima and I were working on it, the Forestry Commission had always maintained that they want uses of the reserve that will preserve the ecological integrity of the reserve. And I know that the Forestry Commission has always maintained this position. So I cannot sit here and fault the Forestry Commission for making whatever recommendation they made to the minister, because they have the technical appreciation. I don't have the technical appreciation.
There's a question I need to ask you. There's this question I need to ask you.
And I know that in 2008, it was 193. I've heard people say 93 acres or 90 acres. It wasn't, because I signed off as the witness for the minister in 2008.
Okay.
And it was 193 plus acres at that time.
There's a question though. When you go through this executive instrument, was there anything done wrong? Is there any suggestion of impropriety in the executive instrument and the subsequent decision to award the lands to the family?
I wouldn't have a reason to have that kind of, I won't say perception, I won't even say conviction, I would say perception. I wouldn't have a reason. Because if you look at how long this process has traveled, this process, I have been familiar with this process in 2006.
Okay.
When the first petition came. So a process that has traveled through former President Kufuor's government, former President Mills's government, former President Mahame's government, and currently President Akufo-Addo's government. This process has traveled through the life of 4 presidents. And I wouldn't have a reason to doubt the integrity and the propriety of the decisions that have been made. I wouldn't have a reason.
Even the amount of land that's been allocated to the family.
That always has been a subject of discussion. Like I told you,
it
was 193 before. And I know that in another period, there were discussions about increasing the size or something.
Okay. But was there justification in increasing the size? What were the considerations?
To be honest, I would believe that the Forestry Commission has given a justification. Okay. Because, mind you, they are the advisors of the Republic of Ghana on this matter.
Now,
and from my workings at the Ministry of Lands, I worked at the Ministry of Lands almost 9 years. The minister doesn't take decisions unless the technical agencies under him have given him good advice. If you look at the Ministry of Lands, how it is set up, there's the Lands Commission, there's the Minerals Commission, there's the Forestry Commission, there's the Geological Survey Authority, and so on. These are the technical agencies that advise the minister on such matters. And I believe the minister would not make any decisions when he doesn't have sound technical and professional input. I wouldn't think that that's the way the minister operates. I know the minister. Okay. I'm privileged to say that. I thought he was my student in Legon. And I know what type of person he is.
The last question here is the claim by Occupy Ghana that Article 20 of the Constitution provides that the original owners of compulsorily acquired lands should be given the first option to acquire them. when those lands are no longer required for the original purpose. But they say they are also aware that the Supreme Court has held that provision does not apply to lands compulsorily acquired before the current constitution came into force, which means that Article 20 does not apply to the Achimota lands, and government is under no obligation to either return this land or any such land or allow the original owners to exercise a first option to purchase.
Yes, the Supreme Court in the case of Ni Probitete Churu against the Attorney General and Lands Commission. This is the Lawaile's case. Yes, yeah. The Supreme Court said that this was a claim brought by the last two. And the Supreme Court said that Article 25 and 6 would not apply in retrospective effect. However, there have been lands which the state took, and the state has, as a matter of political decisions. There is also the question of the vested lands. And there was a case in the Supreme Court that I was part of when I was the lawyer in the Ministry of Lands and Natural Resources. This is the Ninote Omabo and 3 others against Lands Commission and the Attorney General. This is the Osumanche layout case, in which the court said, yes, the lands which were vested before the coming into force of the 1992 Constitution will remain vested. They will not be divested by judicial decisions, but they can be divested by political decisions.
Okay.
So the fact that Article 25 and 6 will not apply retroactively does not take it away from the Republic of Ghana to release government lands when they have to. I mean, it doesn't work like that.
Distinguished Counsel, I am very grateful for your time this evening. And I'm sure when you return to Ghana, we can have more detailed conversations on this land.
Yes, I'm coming back on the 27th. So reserve your other questions. When I come, we'll talk. But I would want to appeal to my Ghanaian compatriots that they should exercise restraint, and that it's not all the things that they are hearing that would be true. And to be honest, the Achimota forest in substantial measure is intact. And it is very intact. And the degazetting is not an alien concept. You know, because most of our people are not familiar with the forest. You know, I mean, even some of us lawyers, not all of us are familiar with the law of the forest. So I would forgive those who don't understand or appreciate the gazetting and so on. They should always consult. They can consult Section 2 and 19 and also look for copies of the judgment of the Court of Appeal in the Forestry Commission versus Metro Mass case. I thank you very much for the audience.
I also appreciate your time with us. Lawyer Kwame Jan was some time ago, and for a very long time, a legal consultant with the Ministry of Lands and Natural Resources. He's known in this republic as a distinguished lecturer in the area of land law, and he joined us to give us some perspective on this particular matter. But I did promise you an interview with the man whose tenor some of these controversies arose. One of the controversies is whether or not the Lands Commission boss at the time, his committee, agreed to give the Owu family 360 acres or 90 acres. That controversy would be resolved as the former Lands and Natural Resources Minister, who has also been to several other ministries for the avoidance of doubt. Lawyer Idris Afseni joins me. You're welcome, sir.
Thank you, Ray.
And I'm happy you're able to join us here. Now, let's one by one deal with the issues. One, he raised the point that as of the time the Kufuor government had done an agreement in 2008 for there to be an extension of the Central Business District in the Achimota forest area, we were talking about giving 190 or so acres to the family. This was before the NDC took over. So there's some dispute about whether or not the NDC is the one that changed it from 90 to 360.
No. So the Kufuor's administration had a different idea of what used to put Achimota forest to. Clearly, we're not thinking of preserving the forest. they were thinking that they should find a place to decongest Accra. And the proper place that came to mind under Kufuor was to turn the Achimota forest into a second central business district. So that's a conceptual, planning under the Kufuor's administration.
Okay.
Now, because of that conceptual planning, that also meant that they could give out any amount of land to the pre-acquisition owners.
Okay.
Because in any case, they were not going to maintain
a forest in the first place.
Good. So when the NDC came into office, and when you look at the 2012 manifesto of the NDC, it stated therein that Achimota Forest will turn into an ecotourism facility. Now, the essence was the NDC recognized and acknowledged the fact that even though large swathes of land had been acquired by the colonial administration as a woodlock for the Achimota school, that land was being encroached upon on a daily basis. And so, how do you protect that land? The only way to protect that land is to put that land to use. Because if the land lies fallow, people will encroach.
Okay.
Okay? And so, and I can give you an example. All the buildings that came up after the Achimota, after the Green Hill College, that is now on the Jimpa, up to Fiesta Royal, that road, left of Fiesta Royal if you are approaching Fiesta Royal, or right of Fiesta Royal if you are approaching Fiesta Royal, up to Noga Hill Hotel, and going up, we're part of the Achimota Forest.
Oh, I see.
Yes. So how did they obtain permits to build them?
Build those ones, yeah.
It's just subject matters of encroachment. Now, as we speak, there are church services and religious activities going on in the forest.
Yeah.
Who gives permission for the people to enter the forest? And when human activity is intense in the forest, it degrades the forest. So you need to manage and regulate human activity. Now, there is an arboretum. Different species of trees. Which species are not available now unless you go deep into the forest, but which can easily be seen by our children and appreciate those trees. Now, so you needed to preserve that. Now, the whole of the Achimota area, there's no place for relaxation. There's no place. So, if you develop it into an ecotourism facility, the people around that area can go and relax.
So that's why the NDC said that we do it.
So because you are going to put it to another use, you could not afford to give 190 acres to the pre-acquisition owners who in any case had been paid compensation.
So why did you increase it to 360?
We didn't. I wrote the letter directing the Forestry Commission to enter into agreement. I don't remember that we even gave them
exactly what acreage did
we didn't even give them 100 acres, or if at most it would have been 100 and over. But it was definitely not even 150.
It was not up to 150?
No.
But you see, this is your word against the current minister.
It's not my word against the current minister. There are documents. I left for the minister for my successor.
I have not shown the document.
No, I left for my successor.
Yes.
The cadastre
of
the area that had been agreed between government, acting through the Forestry Commission and the OU family.
But Occupy Ghana also makes reference to the 2013 agreement.
Yes.
But
and they said 90. Is it 90?
Could that be that they're also referencing 360?
No. They reference 90.
No, my point here.
So when I saw the Gazette, the EI, and I saw 361.5.
Yeah.
I was immediately taken aback. Because if the idea was that they were perfecting legally what NDC had done to give the people an opportunity to enter the land.
Yeah.
NDC did not give 361.5. No. So
is it possible that you did not know, but you know of the committee?
No.
Who set up this committee?
No. I came to meet the committee in office.
Did you approve of their report?
I gave. So I have a letter signed here by myself.
On the 361 or the 90?
No. There's a schedule, but the schedule I don't have on the phone. And let me read the last paragraph. I said one of the major policies of government.
Forgive me. I want to know which letter is this.
This is a letter. This is a letter signed by me, dated 4th of April 2014 to the Executive Secretary Lands Commission. Okay? In the matter of leasehold to pre-acquisition owners, Achimota Forest Reserve.
Okay.
Okay? As I refer to the ownership of the Achimota Forest Reserve, which was acquired by the Republic of Ghana as follows. 1. By a certificate dated 16th December 1921 and 17th May 1927, respectively, the then colonial government compulsorily acquired under the Public Lands Ordinance of 1876 the land on which Achimota School is located.
Is there a part that talks about the acreage involved?
No, there's not a part. There's not a part. By the provisions of the Public Lands Ordinance, a compensation of 4,000
was paid
to the Owu family for the said acquisition, which was duly acknowledged by the accredited representatives of the Owu family. Subsequently, the subject area described in paragraph 1 above was legally constituted as a forest reserve for the purpose of fuel wood plantation.
Okay, so
So let me go to the last paragraph.
Yeah, the point you are,
So the last paragraph, I said, look, so the last but one paragraph. One of the major policies of government is to develop the ecotourism sector to contribute to the economic development of Ghana. The Achimota Forest has consequently been selected to be developed into an ecotourism facility to be known as the Achimota Eco Park. In view of the above and on compassionate grounds, because compensation has been paid, and also in furtherance of the Achimota Eco Park project, the government, represented by the Forestry Commission, has decided to grant a leasehold to the Owu family, the pre-acquisition owners, for a term of 99 years over the piece or parcel of land described in the attached plan and schedules being peripheral portions of the Achimota Forest Reserve.
But there's no mention of
that is attached to the letter, to this letter.
Yeah, but without that, this is not enough to say that we are.
Yes,
because this current minister is disputing what you have said.
So what we need to do is go back to the what was it, 2 days ago document, and see what amount of, what parcel of land was given to Achimota Forest.
Whether it's different from.
Where it's different from. And I can tell you that in your contradiction, that is different. When I even saw the list, I called them and asked. I called the minister and asked, why 361? One, they are no longer considering Achimota Forest as an ecotourism facility.
But he said they are doing so.
No. The minister said no. The minister said no, they are not considering it as it. They just want to reserve the forest.
Yes.
Okay.
Yeah. So, not as a facility for ecotourism. Yes.
Yes. So they just want to leave it as a forest.
Yeah.
That clearly gives them opportunity to give us a large amount of land. Because if you are going to leave it as use it as an ecotourism facility, you cannot.
Could it be that the subsequent minister for you did that?
Then they further explained to me that subsequent to the earlier grant, the land has been subjected to abuse, different uses.
Okay.
And so there has been deterioration. In fact, Kwame Jan called me to say, look, the police station area, which was not heavily degraded, has not been heavily degraded, cannot be used for ecotourism facility. And it cannot be a reserve. Okay. So they rezoned the peripheral areas and it came out to 361.5. So it is not, it clearly,
as of the time you were leaving office, were there more discussions to grant more?
No. We are determined.
See, I'm saying you as an NDC because there
was no discussion. There was no discussion. We had determined.
Not even with Minister Mills.
No. The matter was closed.
Really?
We had determined the area of land that was needed for the ecotourism facility.
Okay.
And we had given what we needed to give to the Owu family. Unless, of course, we were abandoning the ecotourism facility. And you see why the Gazette has raised issue
Okay.
That land is still, and he rightly says so, that land is still under the preserve of the Forestry Commission.
Okay.
So all those buildings that came up in the Forestry Commission had to have permit from the Forestry Commission to develop those buildings, because you needed to develop it consistent with the ecological integrity of the forest.
That's interesting to know. Now, there's this question about the degazetting. Do you also join the school of thought that says, really, it was not warranted?
Well, I believe that the degazetting is what has created the confusion. And they had to go for degazetting for other reasons.
What was the other reason?
Well, they know the reasons. I will not talk.
No, but what are you alleging is the other reason?
If they didn't go for degazetting, there was no way they could grant 361.5.
So that was the reason why they went for the degazetting?
Yeah, so you degazette 361.
To be able to grant more of the lands?
Yes. There was no way.
Not because they were legally mandated to do that?
So the degazetting is now a law, an EI. So 361.5 has been degazetted. This is a law.
Okay.
It's simple.
I see.
So you can now, Forestry Commission is not being drawn into whether or not they want to preserve more than what they have been left with. 361.5 has been degazetted. So it's no longer within the preserve of the Forestry Commission.
Oh,
if you degazette that land, Forestry Commission has absolutely no control over the land.
Yeah, they can't control what's no longer a forest reserve.
Reserve.
Now, the other point also being raised here is that...
So the Tamale case is cited, even though the Lands Commission had purported to grant the deteriorated areas of the Tamale forest for other developments, the court said no, that land, until degazetted, is still under the control of the Forestry Commission.
Now, there's a point, though, that he made that there was nothing wrong with the actions of government on this particular Achimota land issue. Do you agree?
In the sense of what?
In the sense of gazetting, degazetting,
well, I've told
granting
you that
the peace and also going ahead to do what's currently
I've told you that, one, government had to degazette because it was the easier option out of the matter.
Yeah.
To give the Owu family what they had already in 2008 agreed with them.
Okay.
And now even up to 361. You know, in 2008 they had agreed by a memorandum of understanding to give 193. We said no, we couldn't give 193 because we needed the forest for other purposes. Okay.
So you scaled it down.
We scaled it down. So the degazetting gives them an opportunity, and it's
to bring it back up.
Clearly. I mean, we need to.
But you are being blamed for bringing it back up. Is the point that
no. They have even been blamed that I had given the Forestry Commission to a developer to come and raise down the forest. It's not true.
Yeah, that's what they said.
I just listened to Kwame Jan.
Yeah.
He said there was clearly a plan. It was not going to raise down like under Kufuor to be turned into a central division.
To be done an ecotourism park. Okay.
Yes.
Now, there are also some outstanding matters around this particular issue. There are those who are already saying that, so what can the Owu family do on the land now?
Yeah, so when it is degazetted, it's degazetted.
They can do anything at all.
You can do anything. And that is again that...
Whether or not it affects the integrity
of the forest or not. So the land is no longer under the Forestry Commission.
But the minister says they should submit their plans.
No, not the plans.
The minister.
The district special planning.
Yes. Yeah.
So what do you want to build there? What buildings
do you want to be the ones checking the integrity of
again, because the land is no longer going to be under the ministry, under the Forestry Commission. That is why the minister is being constituted under the EI to be the supervisor of the implementation of the district special plan.
Okay, I get your point there.
So you are moving the whole institutional check on use and misuse of the forest and adjoining lands to a minister.
So there's a big question being asked here. The minority in the statement says we should review this. They should actually review this EI that they have put together. Do you support it?
I think that we should understand the basis of the 361.
We should just understand it.
Yeah. How did they come? How did they come by 361.5?
It's not obvious.
It's not obvious. Which part and which part? And this is the work of the journalists, also.
Yes, but to ask for information.
So to ask for information. So which part is the 361? As we speak.
But since they accuse you of giving them 361.
But the accusation is not blame. I'm being accused. Go and establish it.
Yeah.
Well established. I mean, probably they.
So can you boldly challenge government to bring out a letter that suggests that you did it? A committee, the committee that you signed off.
I'm even on your platform saying the government. The committee's recommendation that I implemented did not give up to 100 acres.
Really?
Yes.
Now there is another question though on this particular length. Do you think there's a mad rush for state lands?
Well, you see, the state lands issue, again, the question goes back to the time of Kufuor. When Kufuor came in, there were a lot of petitions to him, and rightly so. We have different state lands. There are lands that were acquired without the payment of compensation. Okay? And the owners were robbed of their resources.
Okay.
And no compensation has been paid. The compensation, when I came into office, was calculated in billions of cedis.
So why is this special? Why is the old family lands in Achimota Forest special?
Old family is simply arguing that, look, so many years ago, 1921, old family was a small family. We just occupied a small land in Osu. Then when government came, colonial government came to request for land, we gave all the land.
I'm getting you.
Now, but
you are saying that the other people making a similar claim. Why is the granting of this lease to old family very important? Why not the other families that have been demanded?
Civil aviation.
Yeah.
Civil aviation. I again worked on the civil aviation, Medina.
Yeah.
We granted part of the land to the original owners. Even though compensation was paid.
So others have also gotten their...
Yes, yes. The compensation was paid.
All right. Now, there's this point, though, about how to safeguard it. The minister says, because of the rules of specifically conflict of interest, government officials cannot go to this old family and go acquire the lands. It would appear they are in a conflicting position. You agree?
Oh, no, I don't agree.
Why?
What is the rule of conflict of interest? I mean, unless you can...
Why? You think that so that I can go and acquire it?
All right. Unless, of course, you can establish conflict. So when you dig-gazette land and return it to... When you return land to the owner, and then...
Can you go and acquire it?
No.
But is it appropriate for you?
No, what I'm saying that...
Does it sound right to you?
What is wrong about it? I'm asking you...
That you dig-gazetted only to go and acquire the land.
Well, that is why we should be asking how they came by the 361.5.
Now, it's a bit confounding.
But again, let's come, I mean, legally. Yeah. So you've dig-gazetted the land. You return the land to the original owners. Yeah. And you say that, no, you shouldn't acquire it. I am yet to see what law will prevent a person from acquiring it, because they go to the open market.
I'm concluding on this point, but there's the point that the Occupy Ghana is making, that they are convinced it is it the 90 acres or the 360 that was released to the 90, family? 90. You believe it's 90?
I believe it's 90.
Okay.
I believe it's not up to 100.
So do you agree with Occupy Ghana that we should not do any subsequent release of the lands in Achimota Forest?
No, Occupy Ghana clearly is raising a very important issue. But that issue is consequent or tangential to what the land is being reserved for. If the land is going to just be a forest reserve, then we have not seen the end yet.
Really?
I'm telling you. They will encroach.
They will go back to it.
They will go back to it.
Minister, we should do more of this conversation. We should look for that document and engage on it.
It's at the Ministry of Lands and Nature. Unfortunately,
I will make an RTR request to get...
Yes, it was a big document.
Okay.
So and I left it in the area as part of my handover notes to my successor.
So it will be conspicuous.
Conspicuous. And then Barbara Asamoah was I put Barbara Asamoah directly in charge of that. So Barbara Asamoah was part of the team.
And you are sure it was not changed?
No, not changed.
Never?
Never.
Well,
it was not changed when I was there. And I never heard, when I left the ministry, that it was changed.
Okay, thank you so much for joining us. Well, folks, that's where we end today's edition of Upfront. Many thanks to you for joining our conversation on the scarce, released, de-gazetted Achimota lands.